Hey guys, Toby Mathis here. Most investors think a living trust is a rich people document. It's not. A living trust is a control document. It keeps your family out of court when you die, and even more importantly, keeps your business and your rentals running if you're alive but can't sign for yourself. And if you own a few properties, let's say 3, 4, 5 rentals, this becomes a real problem fast because real estate doesn't pause when you're gone or when you're incapacitated. Tenants still call, insurance still renews, taxes come due, the mortgage still drafts, repairs still happen. The last thing your grieving family needs when you're gone is to have to go through a lengthy court process in each state where your rentals are located. So today we're going to do this by way that really matters. I'm going to use examples. We'll compare these common setups. I'm going to go through 5 common setups. Ready? I'm just going to write them down so you can remember them. Number 1 is the tried and true do nothing. Number 2 is using a will. Number 3 is using beneficiary designations. So I'm going to call it beneficiaries, like on insurance and things like that. Paid on death, transfer on death, putting those on real estate or accounts. Number 4, let's just call it joint tenancy, adding somebody to an account. So it could be a spouse. Putting my kid on my house, I've seen that a number of times. So we'll do joint tenancy. And then number 5 is using a living trust. So we'll go through an example and I'll put them through each scenario. And I'll explain how this fits, whether you're owning rentals in an LLC, whether you're using land trusts or any other entity stacks. So this is no fluff, no fear mongering, just what happens in real life. So let's jump in. All right, number 1, what is a living trust? A living trust, usually a revocable living trust is what they're called. Inter vivos trust is really just a legal document. It's just a contract that creates a bucket to own your assets while you're alive. And it includes instructions of who manages them and who gets them later. Living trusts are private. They're not filed with any state, and they're designed to keep you out of court and keep your affairs private and to save you time because you're not having to go to court. You're not having to probate these things or go through things like conservatorships, which we'll hear about later. Most of the time, while you're healthy, you just create it. And I said it's a contract. It's a contract between you as a grantor, you as a trustee, and you as a beneficiary. So you're the beneficiary, you're the trustee, you control it, but you're also the beneficiary, you benefit. So day to day, nothing really feels different than if you're just doing everything in your personal name. But the power is this. You're the original trustee, but you have a successor trustee, a person who steps in if you can't act on your own behalf. You're incapacitated. And it continues after you die to manage and distribute assets without you needing to probate it, without them having to probate it. In other words, it's your family that always gets hits with these things, but they're able to follow your directions in the trust. So the living trust helps your family avoid court when managing your stuff at death and at incapacitation, right? Keeps your stuff private and allows you to control your stuff after you're gone. And realistically, it's the gold standard for estate planning in the United States. But what it is not, this is important, it is not a tax hack by itself. Like whenever I see people saying living trust, tax, 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 no, living trust is ignored for tax purposes. It is not asset protection. There is no asset protection in a living trust. So it is not a substitute for using LLCs in real estate or in business or insurance. And I'm going to say this now because it's the number 1 failure point when people use living trust. A trust that isn't funded is really a nice binder that doesn't do too much, right? We can plan around that, but we always add a pour over will to dump assets into the trust if you forget to fund it. But let's do it right the first time. And how does it compare with other options? So we're going to go through them, and I'm going to use an example. So let's just assume you're a normal, successful investor, right? And you have, let's just say you have a house, you're married, maybe you have a blended family. So you have kids from a previous marriage, they have kids. Let's say you have 3 rentals. We'll say 3 rentals, and I won't say where they are. We'll just say they're 3 rentals, and they could be duplexes, multiplexes, single-family homes. You have some cash. Let's say you have a checking, savings. You have a brokerage. You know, we could say a couple cars, but we don't need to put that in. But you have, let's say you have 401k and IRA. So you have some retirement accounts. What else should we throw there? Life insurance. So you got quite a lot going on there, right? And then let's run this through 2 real life events, right? And we're going to do this for each strategy. Event A, and I'll write this over here, A equals you die. Make that really simple. You pass away unexpectedly. Your family needs to access money. They need to keep rents coming in. They may need to sell or refinance something, and they need to run the portfolio. Option B, you're incapacitated. So we're going to go through A and B. So if I say A, you know that. B, you know that. And it's basically, well, you're incapacitated. You have a stroke, you have an accident, dementia. You're still here, but you can't sign documents. And by the way, the second one, this one, incapacitation, is where most plans collapse. Okay, so we have our example. Now let's run it through the 5 different scenarios. We got 5 of them, right? So let's go through scenario 1. Do nothing. We'll figure it out plan. And let's start with the default, what it looks like. Deeds are in your name. The accounts are in your name. Maybe there's an old will, maybe not. No real plan for incapacitation. So let's go through the first scenario. You die. You pass away. Your family is grieving, and now they're doing the scavenger hunt. Where are the accounts? Who has passwords? Who can sign? How do we sell anything? What do we need to do? How many lawyers do we need to hire? How do we pay bills while we're at it? Things aren't set up properly. Your family may need to probate or go through some court process to transfer assets. And that can take, on average, it's anywhere from a year to 18 months. I just went through a low value probate for a client and a friend that I'd known for years and years and years. Ended up in 2 states. And unfortunately, it was what is it called? Insolvent estate, and it's over a year still trying to get through the process. The court process is just slow and expensive. On an income, like, there's no money in this estate, and it's cost over 20 grand, attorney's fees and costs, right? And you're going to say, oh, why didn't he do a trust? Because he didn't. He did some, like one state we managed, where I live, everything was dialed in, took 2 seconds. Other state where he had some other assets, nope. Now let's go over event B. Incapacitated. And this is the killer. If nobody has legal authority to act, families oftentimes end up in what's called a conservatorship or a guardianship process to manage finances. And that's not just expensive, it is slow and invasive. If you think probate's bad, conservatorships are even worse. From an investor standpoint, you could lose, like for rentals especially, you could lose all your momentum. You have missed repairs, which equals liability. You have missed insurance renewals, which means you could have coverage gaps. You could have missed property taxes, which is penalties. Tenants stop paying, and things start to feel chaotic. Doing nothing is like owning rentals with no property manager, no insurance. It's not a plan, it's just hope. Right, now let's do scenario 2. Hey, we have a will only. And a will is better than nothing. But it's common misunderstanding to think, I have a will so I'm covered. Right. What a will does, it's instructions to a court after you die. So event A, you die. A will clarify who gets what, right? But it typically doesn't avoid probate for assets titled in your name. In fact, it requires it. Event B, you're incapacitated. A will does nothing while you're alive. Kicks in when you're dead. So if incapacitation happens, your spouse and kids might still be stuck needing authority to act unless you also have powers of attorney and a plan. Let me just do kind of a investor translation. A will helps with who will get it. It doesn't help with who can run it tomorrow morning if needed. Now let's do scenario 3. I have beneficiaries on everything. I have paid on death. I have transfer on death strategy. And this is very popular for the do-it-yourself crowd. Like, it's just going to go there. Retirement accounts, by the way, I'm happy with this. Retirement accounts, beneficiaries. Life insurance, beneficiaries. Bank accounts, you put a paid on death on them. It's going to whoever that is. Brokerage, transfer on death. And look, the tool can work really well, but let's just kind of go through this of where the wheels can come off. Event A, you die. The assets can transfer outside of probate, and that is a win. But there are traps investors run into nationwide. Not every asset can be transferred this way cleanly. Beneficiary designations can also conflict with your will or your other instructions. And if beneficiaries are minors, money is going to end up under court control anyway. It doesn't coordinate well when you have multiple properties, multiple LLCs, or blended families. You can disinherit your kids. What if the beneficiary that you've named is incapacitated? What if they're getting sued? What if they're in a bad marriage? What if they're a drug addict? What if they're an alcoholic, right? You just handed a match to somebody who's doused in gasoline, boom. We see it all the time. But that's not the worst. You're incapacitated. Event B. Beneficiary designations don't help at all. Your spouse can't access your brokerage just because they're a beneficiary. They can't sign a lease renewal. They can't refinance anything. They cannot sell a rental. You still need authority now, not later. So beneficiaries are a great after-death transfer tool, but they are not a keep the portfolio running tool. So let's go over scenario 4, and hopefully you're starting to see why guys like me are always chirping that you got to put things in writing and have a plan. Because all of these have a hole in it until we get to number 5. But let's go over scenario 4, joint tenancy. This is the easy button. But this easy button creates risk. And this is where people say, I'll just add my spouse to everything, or I'm going to add my kid to the deed. I see this oftentimes with widows especially. They'll add one of their children on. And yes, joint ownership can avoid probate of that asset, but it also comes with serious side effects. Let's go over some of those. Event A, you pass away. Yes, joint tenancy can pass automatically to the surviving joint owner. But what if you added a child? You expose the property to your child's divorces, their creditors. You may have created gift issues when you gave them the interest. They added them onto as a joint tenant. That is a gift of that portion of that interest. You may have also accidentally set up a family fight with your other kids. And you may have complicated what happens if your child predeceases you too. And you lost your step-up in basis, which made something tax-free taxable. In other words, normally you have a house, steps up in basis, joint tenant, sorry, you just lost that. So now something, hey, I could have had $500,000 tax-free. Now it's, nope, now you made a taxable gift. They have basis. So they sell it, they're going to pay tax. So can be a little bit of an out situation. Let's go to B. You're incapacitated. Joint tenancy, Doesn't do anything. It is not an incapacitation plan. Banks and title companies will still ask, who has authority to act for the incapacitated owner? Whoops. So joint tenancy can reduce probate, but it can actually increase risk. It's often a blunt instrument when you need a precise tool. So let's talk about the best tool out there. Scenario 5, using a living trust. And by the way, whenever you do a living trust, it's an estate plan. It's the living trust, it's the power of attorneys for financial, it's the power of attorney for health care, it's HIPAA release, it's schedule of gifting, it's all these things. So a living trust done right, which is, hey, I have all those documents plus I fund it. You're doing a version that actually works for investors. And what done right means, by the way, is you created a trust. You drafted a revocable living trust. You have successor trustees named with backups. And we always put in a catch-all, right? So that the beneficiaries can designate somebody like that if you don't have a named trustee. You have incapacity documents in place, which is the financial power of attorney and healthcare documents. The living trust works itself too. And the trust is funded, which means the assets are placed into the trust properly, which means your LLC membership interest, if you're using a holding company, it's just held in your trust. If you have a corporation, the shares are held by you as trustee of your trust. Now let's go through this. A, same scenarios, right? You pass away. Your successor trustee steps in immediately. I'm incapacitated, I pass away, boom, this is who comes in. They keep collecting rents, payments are all organized, they can pay the bills, they can pay the taxes, they can do everything they can coordinate property management, they can sell or distribute assets per your instructions. And they do all of this without court supervision, without probating the assets, because it's in the trust and it's private. You don't need to file anything. It's a fantastic tool. That's why everybody uses them. And you hear lawyers out there saying everybody needs a trust. This is why. Because they know going to court sucks. Going to court is expensive. There are states with statutes that say you're paying X percentage of the gross value of that state, not net. We don't want that. We want to avoid that if possible. I could say you didn't miss anything if you never go to court. B, you're incapacitated. And this is where the investors really win. This is what I've seen in almost 30 years of practice. You see over and over again, what catches you flat-footed is something happens to me and then the wheels come off. You can't run the business, you can't run the investments. Everybody's running around in circles. If you can't sign, your successor trustee can act for the trust-owned assets without waiting for a judge to get permission. So repairs can get handled, insurance stays clean, gets paid, taxes are paid, the portfolio doesn't kind of drift off and into chaos. But a living trust is not automatic, it's paperwork. If the house isn't titled in the trust doesn't control the house. We can still do a pour-over will, but then we're dealing with a probate on that asset. So if your plan is just a binder, but everything is in your personal name, your family may still end up in court. So the way to look at a trust is it's the operating system and the funding. So I've got Windows. Funding it means I installed it on my computer so I can run it. And when you basically use this, when you own rentals, that's how it works. Let's talk about what most investors' households actually look like, right? So it's rare that you're going to have investors holding their properties in their name. So they're probably holding those rental properties, those 3 rentals, in LLCs, which is great. And so where does the living trust fit in? Well, here's the simple answer. The living trust owns your membership interest in the LLCs, or if you have a holding company, it just needs to own the interest in that one holding company. Meaning, the trust doesn't necessarily have to own the actual house itself. Just by owning the LLC means that's all you have to do. It can own the LLC that owns the rental, and that can help with the continuity of management, avoiding probate on the LLC interest, making the succession clean, making things workable in the event they're incapacitated. And here's the big point. LLCs are not automatically an incapacitation plan, right? Unless you've set up and documented who can act when you can't. So I have to have something that says, hey, if I can't act on myself, who's going to run these things? Well, here it is. It's financial power of attorney, or it's in the trust document. So a trust plus a successor trustee can be the clean who's in charge. And then you kind of, let's just compare the options real quickly of what we just had, right? We had a do nothing, and that would cause a lot of chaos on death and incapacitation. We used a will, which is not much better, but does help with distributions after death and still usually court involved, almost always, and it does not solve anything for incapacitation. We had our paid on death, transfer on death, beneficiaries everywhere, which is, yeah, okay, I can avoid probate for certain accounts, but it does not solve incapacitation. And it absolutely can break with minors, blended families, or any sort of complex ownership. Beneficiaries are great, by the way, for retirement plans, life insurance. Generally, we're going to keep those out of the living trust for that exact reason. And paid on death and transfer on death, they can work, but they come with other issues. So remember gasoline in a match, you're force feeding somebody something, and it may not be what you actually want too, because I got one child, boom. Everybody else I might have just hosed, so I may not want to go that route. Number 4, joint tenancy. Again, it might avoid probate, but it adds creditor and divorce risk. If you put somebody on that title with you, their creditors, their potential divorces cause issues. So there's unintended consequences. And by the way, the tax lawyer in me is absolutely screaming for you not to do it, because it could literally cost you hundreds of thousands of dollars because you missed the step up in basis. So please don't gift things, which is what you're doing when you're putting them in joint tenancy. Number 5, living trust, and this is a funded trust with incapacitation docs, and this is the strongest, no court, no interference continuity. It works great for incapacitation. It coordinates awesome with LLC ownership and real estate. And the honest negatives, I'll give them to you straight up. Here's the big downsides. The living trust is not free. But doing these 1 through 4 aren't free either. There's always a cost. But you know what is free, by the way? I'm going to give you this. The emergency binder. In my gift to you, I'm going to give this to you in e-form so you can download it because you made this far. And let me just explain what the e-binder is. It has everything in there from your doctors, your dentists, who can take care of your animals. It has everything in there about who is acting in what role, where your medical power of attorneys are. It works great when you have a living trust in those documents. Burial instructions, all sorts of things that you need to convey. And then most importantly, it has all your accounts, your social media, your financial, everything, how somebody can get to your user ID. And then we keep the passwords separate. So if somebody gets your binder, they can't access those. They have to know, hey, you keep the password list, and there's a system that we use. So the passwords are not actually in the binder. They're in a special place where you put it in a safe or keep it with somebody you trust. But that e-binder, I'm just going to give it to you. And that's really about half the battle, is making sure you're organizing. How do I get into, this is weird, something happens to you, how do you get into social media? How do you let people know? Hey, I need to continue to operate my business. How do I get access to the bank accounts? That e-binder is going to be the solution for that. And I'll put a link in the show notes so you can just download the binder, or you could type free binder in the comments below and I'll send you a free link to get your free e-binder. Share it with everybody you know. It's something everybody needs. Before you do anything else, that's what I would start with. It's actually the e-binder, because it organizes your affairs so somebody isn't doing the scavenger hunt. If something happens to you, you're incapacitated. Been there, done that, by the way, so I know what that's like. And it takes a load off knowing that you have it organized. All right, so your trade-offs. Setup, cost, and legal work. And by the way, I always say it's worth it when the alternatives are chaos, and probate is more expensive than a living trust, period. We do trusts where all of the updates, if you want to amend it, all that's included. So like some people say, well, living trust, you're going to have to go back to your lawyer every 2 years, da, 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 da. It's all included. But you got to fund it, and you got to keep it updated. And this is important, you need to choose the right successor trustees. You need to choose the right people in your power of attorneys and your trustee. You're giving somebody the ability to act on your behalf. And it can be an institution, by the way. If you say, hey, I don't want to do that to anybody, I just want to have a lawyer, an accountant, or an institution, you could do that too. You need to coordinate with your beneficiary designations too. So your titling, your LLC operation agreements, and insurance, everything needs to draw back to the trust. But here's the key. Most living trust problems come from what I would say is sloppy implementation. It's not the trust itself. It's that it's kind of like the computer with the operating system. You never install the operating system. So I would say this, and I would say this to anybody, I would strongly consider a living trust, and I'll just make this a checklist. If you check any of these boxes, a living trust moves from being a maybe to a really smart. You own real estate in any meaningful amount. You have more than one property or more than one LLC. You want to avoid court involvement. You care about privacy. Because remember, probate is public, living trusts are private. If you have minor children, you got to put that in writing as to who's going to help them. So you got to make sure that you have some sort of plan, not just a will. If you have a blended family situation, it's very easy to disinherit somebody. You got to make sure that you're covering that by using a smart estate plan. If you want a clean, who's going to take over if something happens to me tomorrow answer. And if you're an investor, here's the question that should settle it. If I was in a car accident tonight and I was incapacitated for a period of time, let's just say 90 days, who runs my portfolio? If the answer is I don't know, you need to have a plan. And living trusts are one of the best tools for that. By the way, if this helped, like and subscribe, please, and grab the free emergency binder. If you want the beautiful one in the red binders, you just stick it on a shelf so everybody can grab it. You can absolutely buy that, but I'm going to give you the free e-binder, and if you want to talk to somebody about setting up a living trust, you can do that too. I'll send you, it'll be included with the link where you can set up a time to talk to somebody if you want. It's not a requirement. And by the way, if you think somebody else could benefit from an e-binder, share it with anybody that you think would benefit or anybody that you care about. Till next time, thanks guys.